Welcome to another episode of Legal for Tech, the podcast. So guys, you know it's always Rosie here, and well, it's nice to see you again. Not really, but anyways. And as you know, I've said it many times, we are just a group of students and young professionals who are very interested in anything that has to do with technology and, well, its regulation. So today, in person, I am joined by my good friends and colleagues, Giacomo and Giacomo. Hi, guys.
Hi, Rosie.
Hi, Rosie.
Pleasure to see you again.
Yeah.
Little spoiler here. And we are calling you, well, actually recording this, from the European Commission, where we'll be invited by a great friend of the podcast, Pierre Bichet. Thank you, Pierre.
My pleasure.
It's great to see you. It's great to finally get to know you, because this has been going on for a long time. I had to book my plane tickets. And we want to know, first of all, something about your career. How did you get here? Tell us all about it. We never heard about it, of course.
Sure. Well, first, thank you so much for the invitation. It's a great pleasure to be here with you today. I think for the competition bubble, I have a pretty standard background. I did my law university in Paris. Then I wanted to specialize in competition law. Back in the day, the offering wasn't as big as it is now, so I went to College of Europe in Bruges. After that, I came to Brussels, where I spent over a decade in private practice in different law firms, working on a variety of competition law matters, from mergers to antitrust to cartels. And I was fortunate enough to pass a concours that allowed me to integrate the European Commission and DG Comp almost 4 years ago. And yeah, so things have been very different in the last 4 years compared to what I was doing in private practice, but I'm very happy to have done both.
Maybe this will be the first time that you will hear this question. So, can you share a moment or a case in your career that sparked your passion for competition law? Was there a defining experience that you set you on this path?
Okay. I'm probably going to break your heart here, but I wasn't born being passionate about competition law. It's just a process that evolved and materialized over time. I think it's pretty cliche, but a lot of competition lawyers like law and like the economics. So competition law is, a good mix of both. And then I was just fortunate enough to have interesting European teachers and competition law teachers, which, reinforced my belief that this is what I wanted to do. Then I wanted to see what in practice it looked like. So I did a couple of summer traineeships in law firms to actually see, how is this applied in practice? And that really confirmed my belief that I wanted to do competition law. And competition law is still fairly recent. It's not the oldest of statutes. So, we're fortunate enough that it evolves quite quickly. So there's never really a dull day when you do competition law.
So, since you advise on mergers and regulatory issues, we would like to know if you see any new trends and challenges in the competition law, in the European competition law, also seeing like what is happening right now in the US. And also, I read something about saying like till now, the paradigm of competition law was having more companies is going to give you a lower price for the consumers, but maybe something is changing in this way, because also they were saying that since the big scale of these companies, they can also, if they are like monopolies, they can give you lower prices.
Yeah. So what you're saying is basically the natural consequence of a competitive process, right? If companies can compete freely and without restrictions, the outcome will actually be lower prices for consumers, more innovative products, better after services. I think that when you think about competition law, that's what it's supposed to achieve, and I think that no one really contests anymore. Your point on the bigger companies is true, right? If you're a bigger company, you'll have economies of scale. There's obviously some efficiencies that might translate in lower prices. And if you look at European competition law, we don't take any issue with, having market power. Being a so-called dominant company in itself is fine. So, it might be that, okay, they're dominant, but, they're dominant because they're the best player out there, their products are the best. And it's not because you're a big company that you will necessarily price higher. What we see, however, is this trend in the US that you mentioned, but also in Europe, where industries tend to be more and more consolidated. So, you have less competition and you might have less players, one very big and others that try to compete. And we just have to be careful that, those situations don't lead to bad market outcomes, right? That the company has become so dominant that it's actually not investing anymore, not putting innovative products on the market, that it is not constrained, so it can charge excessive prices because at the end of the day, no one can really compete. So, obviously, the more competition you have, I think the outcomes that you mentioned are natural. But we as regulators have to keep an eye on, market structures to make sure that we do get those benefits.
Is there a geopolitical significance in this selection of companies you do? Like, do you also, like, if a company is from the US, for example, or China, these are big supranational powers, do you think like, maybe they need a bit less importance, whilst if a company is European, maybe you can close an eye?
It is a good question. And obviously, I think it's very lively, right, with the Trump 2.0 administration. At least in Europe, the situation has always been that we champion an open and free economy and a free market. The condition, of course, is that you comply with the rules. So our market is open to everyone, but you need to comply with our rules. So the nationalities as such don't matter at all. It might be that in practice it happens that, digital platforms, the main ones, might come from the US, but we'll never introduce a tool that's targeted specifically at companies of a certain nationality, right? Is everyone's free to come, everyone's free to do business. The only condition is that you respect the rules. If you don't respect the rules, it doesn't matter where you come from. You can be Chinese, you can be European, you can be American, South African. It doesn't matter at all. So I think nationalities of companies active in Europe will never be a relevant criteria.
The European Commission recently fined Meta nearly 800 million euros for practices related to Facebook Marketplace. Could you elaborate on the significance of this case and the implication for the digital platforms?
Indeed. So it was end of last year where the Commission imposed, as you rightly said, so a fine of 800 million euros on Meta, and for abuse of dominance. And there were really two strings to the case. One was a sort of more classical theory of harm, which was tying. So every user of the social media, Facebook, would have access to the Facebook Marketplace, which is their online classified ad service. Whether you like it or not, you go on Facebook and you see all of this. And obviously that created an advantage to the Meta classified ad service because they have a huge distribution channel, which is all the users from the social media, whereas the competitors of the online classified ads don't have access to that pool of people. So by tying one to the other, you gave an advantage to your own services. The other one, which was probably a bit newer in the way to approach things, was the imposition on unfair trading conditions, where Meta was applying these conditions to people advertising through Instagram and other Meta services, conditions that were unfair, meaning that then Meta could use the data from the service to its own advantage. And this is something relatively not new, but there's an uptake in this theory of harm, which is unfair trading conditions, which exists in Article 102A, which we see a lot when it comes to excessive pricing, but we didn't necessarily see it applied much in non-pricing terms and conditions. But we had in March 2024, the music streaming case against Apple, which was also based on 102A, unfair trading conditions. And now we have the Meta example. So that's two cases in a very recent time, both under appeal. So ultimately, we'll see what the judges say. But what it means for digital platforms is that, as a regulator, we are seeing more and more practices that, look unfair. And this gives us potentially a new avenue to tackle, these practices. And I think, generally speaking, especially when it comes to digital, these markets and these companies are so large that, regulators all around the world, not just in Europe, but all around the world, are actually pushing the boundaries of abuse of dominance and monopolization to try to capture practices that don't seem right.
Wouldn't you say that, though? I mean, digital platforms are built, especially Facebook, for example. I mean, there are studies that explain like how Facebook became an infrastructure rather than just a social network. Like they started off a social network, and then they did this kind of like infrastructurization process. Wouldn't you say that, like, I mean, that is the business model of a digital platform? Isn't the European Commission perhaps like being too much interested in like deciding on the business model of a service? Why?
No, it's a fair question. Again, at the European Commission or as regulators, we will never, dictate a specific business model, right? Everyone is free to conduct business as they wish, with the framework and the caveat that you need to respect the rules. As you say, these companies, you use the word infrastructure, not me, but their business model is also that they're two-sided markets, right? There's always two sides to the platforms. They have the advertisers on one side and the users on the other one. If you take an app store, which is the same, you need the developers are going to develop their apps, and then you'll have the users, and then it creates like a snowball effect, right? You will never download an app store if there's only 3 apps in them, right? Because it's not attractive. You will not use a messaging service if none of your friends are using it. So that's when it becomes tricky, is because you have these two sides. At one point, you will have conflicts, right? And sometimes these platforms also compete. So it's not just about, this is my platform, this is my infrastructure, to use your terms, that I can do whatever I can. You are dealing with, people upstream, people downstream, and you might have conflicts of interest either upstream or downstream. And that we'll need to tackle when it's a problem.
So the Digital Markets Act has been a big milestone in the European Commission regulatory landscape. And for example, I was on an event last week, and they were saying like maybe with the omnibus we're gonna see some changes in the AI Act, but the DMA is like something that is there, and we don't want to change it, despite like Trump and Elon Musk pushing a lot and on this case. Do you think that in the implementation, this blow from the US is going to arise a lot of challenges in the implementation of the Digital Markets Act? Do you think it would be really difficult to apply the Digital Markets Act to, for example, US companies, or it's gonna be pretty smooth and that's it?
Yeah. So let me break your question down into 2 different aspects, more on the challenges, right? I think the first one, you're right to say the DMA is here to stay. And it's a brand new instrument. It hasn't been enforced for a very long time. We are now currently knee-deep in implementation and compliance, period. As you know, the DMA applies only to a handful of companies. As of now, we have designated 7 gatekeepers for a total of 24 core platform services. These companies need to comply with the DMA. I think we have already seen tangible changes. For example, if you have an iPhone, now you can download alternative app stores, or you can download apps via the web, which you couldn't do before. If you have an Android device, you don't need to use your Gmail account to sign up to another Google service, which was not the case before. Now with the sun coming up, you're thinking about your holidays. Hotels, for example, have more freedom in the way they price, and you don't need to go via booking.com to find the best deal. So, there are tangible changes. It's a marathon, it's not a sprint. A lot of this will materialize over time, but it doesn't mean there's no challenges, right? I think that there's two challenges. I mean, there's potentially more, but that quickly come to mind. The first one is this asymmetry of information. You said it before, it's large companies with a very specific business model, and obviously they know their business better than everyone else, which is pretty reassuring, right? You would expect them to know their business. But they need to comply, and they need to explain how they have complied. But sometimes it's very technical. There are companies with thousands and thousands and thousands of employees. We are a much more restricted team. And, often developers and beneficiaries of the DMA will not fully understand what they have done or why they're doing. So, these companies have a lot of information that we don't have, and trying to bridge that gap of information is difficult and makes it difficult for a regulator to then understand whether they're complying or not. So that's one challenge, right? Then the second challenge, as you said, is, regulation can quickly become very politicized. Digital, you mentioned the omnibus, it's environmental, but, it has been heavily politicized. Trump 2.0 is a bit of a difficult animal. He adopted this executive order in February about, fines on American companies and innovators, saying that, there might be retaliation. I think I said it before, the position, at least in Europe, is very clear. We don't go after companies by nationality. Amongst the 7 gatekeepers, we have, of course, a handful of American companies, but we have a Chinese company, we have European companies. The only rule is you do business, you're more than welcome, but you need to comply with the rules. Of course, when you have such a threat, then all of it becomes very political, right? But the signal that we have at least seen from our vice presidents, the 2 vice presidents that oversee the Digital Markets Act, is that we will continue enforcing the DMA, like it or not, and anything else is more for our politicians and than for us at the case handling level.
And we're very happy of that. But following up on this, and by the way, it's like 1 year of the Digital Markets Act now, so more or less.
The gatekeepers that were designated in September 2003 had to comply as of 7th of March 2024. So we're really going into like the first year of compliance.
So
we'll celebrate together.
Yeah, we need to celebrate. But following up on this, I want just briefly to bring the AI in the room. Of course, like DMA, if I'm correct, doesn't target like AI, but like AI, for example, it comes up to my mind that now is becoming for the research, like as it is for Google and Bing, that are like you can search by that. AI also is becoming like a big thing on this case. Do you think like that could be the case that also AI companies would be targeted under this?
So there's a lot of things. The first thing is, what is AI? Are you targeting the large language models? Are you assimilating them to like almost an operating system in the way they work? So first there's a question on definition of what AI is. But the DMA is a regulation that is targeted. So it only applies, as I said, to certain companies, which are gatekeepers, and it only applies to 10 what we call core platform services. And AI as such is not in the list. So the easy answer would be the DMA doesn't apply to AI because AI is not in the scope. Obviously, if you use AI as part of one of the core platform services, then there's room for the DMA to apply. So you said now, you can go to an online search engine and you might have AI generated overviews on top before you have like your blue links, etc. Obviously, then this is part of your search engine, and search engine is a core platform services, which means that the obligations apply. So you cannot, for example, favor your own services compared to the ones of other parties. So when you generate results via AI, you can also not, favor your own services compared to someone else. So there's some room for the DMA to apply. The same, there was, I think it was yesterday or 2 days ago, that Amazon is reviving Alexa, but like AI version of Alexa. So Alexa is a virtual assistant. And the DMA, again, has virtual assistants as a core platform service. No gatekeeper has been designated for the virtual assistants for now. Well, it might be that, if virtual assistants become really trendy because they do a good job because they're AI powered, then it might be that they get designated and then the DMA applies. So there is some room for some AI applications to be covered by the DMA.
In your role as a case handler with the European Commission, how do you approach balancing the legal analysis with broader policy consideration when you're assessing the case?
It's a good question. I think I probably need to explain you what a case handler is or does.
Absolutely.
And I think that will naturally respond to your question. We, case handlers, are here to check that the law is respected. In our case, in this tower, competition rules, in my specific case, the Digital Markets Act. So we don't create the rules. We don't, that's not our role. Our role is literally to double check and make sure that everyone is compliant with the rules. So we will apply the law as it's written in the text, as it's interpreted by the Court of Justice, but we don't change and we don't replace the Court of Justice, right? If we don't agree with a judgment of the Court of Justice, tough luck, that's the ultimate power. Of course, we are sometimes led to situations where we have to apply competition law in novel situations, right? There's new products out there, there's, services that didn't exist 10 years ago, but we still need to apply the same framework, which has been existing for long, to these new situations, right? If you take the famous Google Shopping case, for example, that was really applying competition law, but, to a service that hadn't been really investigated before. Doesn't mean that we created a whole new law. It just meant that we apply, in that case, the rules on abuse of dominance to a new framework. Our role will then be to see whether, in line with the interpretation of the rules and what the court says, there is space to integrate some policy considerations, right? And for example, you can think about sustainability agreements. There's been a lot of discussion about, is competition law really stopping sustainability initiatives and innovation because people are afraid that, they might fall foul of the cartel rules, for example. So then there's a rule to see, well, can we interpret Article 101 in view of what the treaty says and the court says in a way that maybe we can allow, or on the contrary, that we're stricter. But again, this will always be within the principles that have been determined by the court. If we really need to change the rules to factor in broader policy considerations, then this is the role of the policymakers. It's not really us as a case handlers.
In that, looking at the working of the European Court of Justice, do you wish that they, keep quiet for a bit about the DMA, or do you want a ruling coming out soon?
That's a good question. Well, for now, we only have one substantive judgment on the DMA, which is in favor of the Commission. So if all the judgments could follow the same trajectory, we'd be very happy. But no, then again, obviously the Court of Justice is an independent body. And I think what also makes our legal system valuable and trustworthy and robust is that everything we do can be subject to judicial scrutiny. Sometimes, we need the court to tell us what the rules should be, or say, yes, you interpreted the right way, or your interpretation is completely off the mark. Tough luck, you need to go back to the drawing board. So I'm personally always very happy when we have tangible, substantive judgments from the court, because it gives you a lot of legal certainty.
And do you think that private companies think the same?
That's also the difference, and that's why I also moved from private practice from the Commission. Is our role here is to protect the general interests. Companies are there to represent their own interests. So depending on whether it goes in favor or against their interests, they'll be happy or unhappy. But it is the way it is.
Well, we will ask Google, of course. You're more than welcome, Sasha and Adela, to come on this platform. So, before we let you go, there is the question that we ask everybody. I promise, it's everybody. It's not just targeting you, just because we're live. The question is, based on what you've just talked to us about, so we're talking about European competition law, and especially the new kind of field in which it's operating, so digital markets and digital platforms. Do you have a suggestion of book, TV series, podcast, apart from ours, of course, everything that may help our listeners dive into this topic a bit better and with a greater level of knowledge? Because, this is very important. This is, our everyday, literally.
Specifically to digital, maybe not.
Okay.
And probably, not that there's not, but if I can take a step back, is, okay, all of this is very important. But I think there's like a whole brave world outside. And honestly, I would more advocate that you read and you listen and you watch something else. Build your culture, than spend 24/7 listening to legal and tech, where you might lose a bit your independence of thinking. But there's a couple of good podcasts. There's a Curious Amalgam from the American Bar Association that's all antitrust. So sometimes it'll be very like American driven, sometimes it'll be very niche, but they talk about basically everything that's happening in the world. So you have podcasts about, what's the influence of having a president that's very, conservative or very liberal, or there's this new regulation, what does it mean? So it covers a broad amount of topics on antitrust. If you want to know about European law more in general, a bit of competition, but more general, how Europe works and what Europe does for you and how the European Court of Justice works. There's this podcast called Europa Felix. That's also very good. But yeah, I tend to read other stuff once I'm home.
So what's your favorite book?
My favorite book. So it's in French, but it's called Un arc-en-ciel dans la nuit. Mm-hmm. And it's about the history of South Africa from like back in the day where there was no one and people needed a stop to eat meat so the crews wouldn't die, to how the different tribes got together and the apartheid and where South Africa is now. So it's a really good book. Honestly, it's very eye-opening.
Wow. So between, South Africa and competition, this was an amazing conversation that we had here in Brussels at the European Commission with Pierre Bichet. Thank you so much.
No, thank you for having me. It was a great pleasure.
Thank you for having us, actually. And that is all from Legal for Tech, the podcast. Thank you guys for joining me today, joining us.
Thank you so much.